Welcome to Redefining Competencies for the 21st Century Lawyer, Improving the Client Experience. We begin today by acknowledging that this session is broadcast from the traditional and unceded territories of the Coast Salish peoples, namely the Squamish, Musqueam, and Tsleil-Waututh nations. Those joining us from throughout the province, and indeed the entire country, are joining and are similarly situated on traditional territories of Indigenous peoples. No matter where we are, we acknowledge and appreciate the opportunity to gather on these lands. In doing so, as members of the legal profession, we are mindful of the impact Canadian laws and policies have had on Indigenous people in our province and throughout the country. And we look for opportunities to learn about that impact and in turn reform those laws, policies, and practices. My name is Carrie Simmons. I use the pronouns she and her, and I am the Executive Director of the BC branch of the Canadian Bar Association. Today, I am your host and moderator. So, why are we here? The Honorable David Eby, our Attorney General, proclaimed this week Access to Justice Week in British Columbia, giving us all an opportunity to highlight the progress we have made to increase access to justice in BC and see what else we can do. And when I say us, I mean lawyers, law students, educators, judges, community advocates. I mean institutions like the Law Society and law schools, government, associations like CBA BC, and key service providers such as our courts and tribunals, continuing legal education, public information societies, Legal Aid BC, and courthouse libraries. You know, there's a lot of progress being made, and every small improvement, which may seem insignificant in isolation, can compound to create amazing results. We need to keep going, and we need to get better at destroying the barriers that make progress difficult. We need to keep learning more and challenging established ways. That's what tonight is all about. This event is made possible by the Law Foundation, the Law Society, the Continuing Legal Education Society, Access to Justice BC, and the CBA BC branch. There are over 150 people anticipated to join us throughout the evening tonight, and I know even more will watch the recording in the weeks to come. We're here today to talk about the connection between lawyer competencies and access to justice. Our focus is what a lawyer in today's world needs to know and be able to do to best serve their clients. The approach that we are going to talk about may be different than what some of us learned in law schools or what we experienced when we began to start practice. But for those of us who concentrate on serving our clients, to fulfill the purpose and role we have within the legal profession, to meet with witnesses, to talk to experts, we know that we need to continually evolve our skill set, our knowledge base. Being a lawyer requires continuous learning, and that is part of what we're going to examine today. To launch our learning today, we're pleased to introduce you to Jordan Furlong. Now, Jordan is an internationally renowned legal sector analyst. He's an author, a speaker, and a consultant, and he's been forecasting new developments and discerning emerging patterns in the legal ecosystem for more than 20 years. You can look more about his writing at law21.ca. Now, I first came to know Jordan when he was the editor of National Magazine for the Canadian Bar Association. He'd practiced law, he moved into being a legal journalist, and then after that, he started to study what is going on in the legal profession. You know, you may wonder, Jordan's not an academic. He doesn't teach law. He practiced for a little bit. How come he's talking to us about the competencies of lawyers? Well, that's because Jordan has dedicated himself to studying legal services, lawyer development, lawyer education, how lawyers are regulated, the institutions that give us that grounding for our legal profession. And he looks at what clients are saying and what our society actually needs. He takes all of what he hears, analyzes it, and provides thoughts, recommendations that ultimately contribute to improvements to the legal profession and our society today. So as a follower of law21.ca for the past decade, I can tell you that I don't always agree with what Jordan says. But always what he says enables me to enhance my views about what I believe to be true and what we need to do as a profession. It helps me to contribute to the conversations with others to improve lawyers, our profession, and improve how we deliver legal services. So I'm looking forward to hearing what Jordan says today. I'm sure all of you are as well. Please remember to put your questions in the Q&A. Jordan, now over to you.
Thank you very much, Carrie. Good afternoon and good evening, everyone. Thank you kindly for the opportunity to join you during A2J week and to be part of this really important initiative and this really interesting conversation tonight. And if all goes well, you should have on your screen right now some lovely mountains, which Google Images assures me are from British Columbia. And the subtitle, How Lawyer Competence Frameworks Can Help Address the Access to Justice Crisis and More, which now that I say it out loud is kind of a clunky subtitle, and I guess I might shorten that next time. But I guess the larger issue for me is the bigger title, which is beyond accessibility. And it's that beyond sense I'm going to be focusing on a little bit today. As Carrie has mentioned, we are going to be talking about two issues, access to justice and the competence of lawyers. And I'm going to be hopefully showing how they can and need to work together and evolve together over the course of the coming years and decades if we are to make real strides and improvements in both. That having been said, and maybe Carrie was foreshadowing a little bit with her comments about not always agreeing, I will be pushing beyond in some places. I will be making some observations or suggestions or ideas that may be a little provocative and maybe a little bit outside the traditional envelope, because I believe it's where we need to go. Right, we need to spend some time outside of our comfort zones and consider and look at things in ways we haven't necessarily done before. So with that as an introduction, I thought we would jump in and start talking about A2J, access to justice. And it seems to me the best place to start with that is with the A2J Triple Aim. Now, I'm sure that all of you here today are familiar with the Access to Justice Triple Aim. It is the framework, or it's the goal. It's the system that has been adopted in British Columbia in order to tie in all of the elements of the effort and the drive to improve access to justice and try to make them work together rather than kind of being in conflict, sort of saying, well, we need some of this, but we can't afford any of that, and fighting over bandwidth in this area. It's more of an attempt to make all of these different areas come together. And again, if you're familiar with the idea of a triple aim, it derives originally from the International Health Institute, which put together a triple aim for access to health. Interestingly, more recently, the IHI has added made that a quadruple aim. They have added in the question of burnout of health professionals, obviously something the pandemic has keyed us in on. And there are even discussions of making it a quintuple aim to work in areas of health equity so that communities that have traditionally been ignored or overlooked or poorly served can be part of the conversation as well. All of which is to say there are multiple elements involved in any effort to really synthesize all the features of access. And when we look at the A2J Triple Aim, we find that there are tripartite goals. We want to improve what's called the population access to justice. We want to improve the user experience of access to justice, and we want to improve costs. The way that I tend to interpret that, and this is just one person's angle on it, is when I look at population access to justice, I think of this in terms of people's general legal health, because this does kind of parallel the medical or the healthcare aspect of how healthy is our population, how healthy are people in the country generally. And if you translate that to legal terms, I think you find yourself saying, what is the state and the status and the effectiveness of people's awareness of the law and of their legal rights, their proficiency in being able to navigate and manage and work their way through. How confident are people when it comes to the law and their ability to understand what's available to them? And what options are available to them for remedies? And again, there's all sorts of parallels here with the healthcare side of things, which we can talk through. But I think that's generally that one angle that we want to make sure is important. We also have the question of the experience of access to justice, which, among other things, but I think primarily involves what is the state of the justice system. Fundamentally, are we getting delivery of legal services in a timely and affordable and effective and accessible manner? And if in fact we are not, and spoiler alert, we're not, how can we make improvements in that area? And then there's a question of resource management, because while I would love to see legal care in this country to be supported publicly to even a fraction of the degree of healthcare, that may be a little ways off yet. So we still have to kind of manage our resources and our costs. So I think the A2J Triple Aim is a great framework. There is a measurement framework in place, which I'm not going to go into because that's a little too much detail. But there's a couple of pieces about this I do want to maybe pose a couple of questions about, or pose a couple of thoughts for further reflection. The first of these is my last entry in the slide, which is we get a pretty good sense, I think, or we're developing a better sense all the time of point A in this process, right? We're still collecting data, we're still collecting evidence, we're still trying to get a sense of what is the status of access to justice in our society. We are considerably better off than we were 10 or 15 years ago. We are nowhere close to where we need to be, but at least we've got a decent picture forming of what you might call point A. So the question I think we want to really address ourselves to here is, so what's point B, right? What does it look like if the A2J Triple Aim succeeds? And what kind of time frame are we talking about? And what are the metrics? What are the signs to show that we have arrived at our destination? Roadmaps are really important, I think, but every roadmap needs a destination. So what would be success for access to justice? Not even for the Triple Aim, just generally. What would access to justice look like in concrete terms? Would it mean that if you did a survey, 50% of people of British Columbia or Canada would say, yes, they are confident and that they can access, and they easily, readily, conveniently can access legal solutions whenever they want, right? I'm not saying that's the goal that you should adopt, but it's an example of a goal that you can kind of choose to say, okay, that's what point B would look like. That is also not to say there can't be a point C, point D, point whatever, but I think it's important that in order for us to measure the impact of what we're doing, we want to think about where we want to get to specifically. The other point I want to make is each of these three elements of the A2J Triple Aim makes me think of three separate things that I think we can do as a profession, we can do as the administrators of the legal sector, for lack of a better term, to really help drive us in that direction and give some more depth to these ideas. And the three that I want to talk about, I would classify as empowerment, infrastructure, and diversification. And what do any of those mean in this context? Well, let me tell you what I'm talking about. Let's take a look at the whole question of empowerment. One of my issues with the access to justice efforts we've undertaken in the legal profession over the past, well, decades, frankly, we've been talking about this for the full 25 plus years I have spent in the legal profession, and for longer than that. But almost all of our conversations revolve around the supply side, right? Because that's where we are as lawyers. We're on the supply side of the legal market, of the legal sector. We're the ones delivering services. And when we talk about improving access, we tend to default into how can we improve supply? How can we make more lawyers available to more people? Is that a question of lawyers have to charge less? Is it a question of lawyers need more legal aid funding? Is it a question of lawyers have to be doing more pro bono? And I'm not saying any of these or all of these is correct. I'm just saying these are the kind of questions we ask. And even when you look at innovative efforts, really good, to my way of thinking, innovative efforts to expand supply, the Law Society of BC Sandbox, of course, is a sterling example of this. Then we also are talking about how could we make more channels open? How can we open up more doors people can walk through to get the justice they want? All of that is good and fine and necessary, but I think it overlooks the demand side. right? The people who need legal help, the people who need legal services. And I'm saying people here as kind of a shorthand to represent individuals and families and small businesses and companies, whatever, like the Fortune 100, I don't care, but we'll talk about people for convenience sake, right? How do we empower people in terms of their justice knowledge, their justice capacity? And this goes back to what I mentioned earlier, the whole question of the health. How do you make people healthier in and of themselves? So this involves giving people knowledge of their legal rights. What are your rights legally? What are you entitled to as a person who lives in this province, in this country? Can we provide tools that they can self-assess where they are? Can we help them understand there's ways you can remedy your own situation to a certain extent, and you can inform yourself as to your options, and there are systemic solutions out there. Do you know where to find those? And again, for me, the model here goes back to the whole question of health literacy and health education, because we've done a terrific job of that, I think, as a society, in helping people really become more empowered health-wise. People have a real good sense of their everyday health needs. They have multiple options for getting health information and health assistance. If you're not feeling great, never mind COVID, if you're not feeling great generally, you can pick up the phone and call it telehealth and get a public health nurse talking to you. Or you can go to the pharmacist and ask the person on the little platform, hey, what's wrong with me? You know, what do you suggest over the counter? You go to see a doctor, whatever. There's a multiplicity of options. So how can we do that in the legal world? Well, we could really push public legal education a lot harder and give it a lot more money than we do. Because in my experience, PLE has been a tertiary at best consideration of the legal profession in terms of helping people understand what they're entitled to. Improving legal literacy. I would love to see public service campaigns. I would love to see high school law courses be mandatory. I would like to see civics as well. I like to see a lot of things, but a high school law course, I think, would be tremendously useful to help people understand, okay, now I get a bit better sense of what the structure of the law is, how it can work for me, what I can do. You know, I it makes a bit of a joke sometimes, but I say, why don't we have legal rights fridge magnets? Right? I get a magnet in my fridge downstairs for signs of a stroke because, you know, I'm that age, right? And I got the little FAST acronym, face, arms, speech, and time. And every time I open the fridge, I see, hey, there's the FAST thing. Ooh, look at that, right? And surely there are ways in which we can democratize knowledge of information about the law, give it to people, improve their confidence, improve their own ability to navigate the legal system with more assertiveness, which I think they are fully entitled to. So again, upgrading demand is my suggestion here. I think we could spend a lot more time doing that, and I think we can bring in many other partners from outside the legal profession to help us to achieve that. Kind of related to this, for me, is the whole question of infrastructure, because we need a much more robust infrastructure for legal help, legal services, legal solutions than we have. I've written in the past about the idea of an online justice hub, right? Which is not that difficult, I think, to conceive. An online resource where you can go and ask questions and you can present information and say, this is the overall scenario. This is the broad strokes of my situation. What are my rights? What are my remedies? What are my entitlements? Where can I go for assistance? What can I do to find a way forward? And to the extent that you can build in the automatic enforcement of those rights where it's appropriate, all the better. And not to say we should only be looking at online. Obviously, that's a great way to scale solutions. But physical justice hubs are also equally important. Many communities now, you'll find libraries are places where legal information, legal navigation can be provided. Same thing for community centers. Same thing. I saw just the other day in Britain, they're looking to use hospitals, which is a great idea. The people I know in the medical legal community are thrilled about that idea, right? Because again, you go where people are. You meet people where they are to give them the information that they need. This is also a good opportunity to talk about the fact that whatever the relative merits of our court system, it is not designed for, and it is not being used by the vast majority of people who have issues that have conflicts or disputes or problems that need resolution of some kind, right? Courts are expert systems. The line I like to use is that every courthouse should have the same kind of sign on it that a step-down transformer does, the big lightning bolt saying, do not enter here unless you are a trained technician. You may suffer great damage or die if you do this, right? It's the same basic idea, but of course, non-expert people, ordinary, normal people, as I like to call non-lawyers, come into the courthouse all the time, and it's not meant for them. The court system is not meant for everyday people. Okay, so we need to develop a system that is, because the disputes are still out there and people still need the help. This is my chance to, as always, wave a big old flag for the Civil Resolution Tribunal, which is, to my mind, the single most successful innovation in access to justice anywhere in North America over the last decade, and which I wish every other province would and territory would adopt. My view on this is that the justice system is vastly, vastly underfunded in Canada, but you know what? It's also over-privatized. I think there's too many solutions to the whole problem. It says, oh, we'll just get lawyers to do this, or we'll just find a way to build a business to do that. The public sector has to play a greater role in legal services solutions. I don't think that's a radical idea. We do it for healthcare. I think we can do it for legal care as well. Final point I want to make here, and it ties into that last one, is the whole area of diversification. Because when we talk about, now we're going back on the supply side, and the supply side of the legal services market since basically forever has been lawyers, and that's it. And lawyers do a wonderful job. I'm quite serious about that. Lawyers do a great job serving their clients. But we have many studies in hand from multiple jurisdictions telling us that the sum total of all lawyer clients, if you will, represents maybe 15–17% of the entire population of people and legal issues and problems and worries and concerns that are out there not getting dealt with. And you know what? If lawyers alone could have solved the access to justice crisis, we would have done that decades ago, right? We wouldn't be having this conversation, or we'd be having a very different one. But we haven't, because I don't think we can do this alone. Doctors alone do not and cannot provide all healthcare services. I heard a stat one time that suggests doctors provide maybe 4% of all healthcare services. Lawyers provide well over half of all legal services. So we need to find allied professionals. We need to develop them and encourage them and ally with them and partner with them and work with them. Paraprofessionals, court navigators, social workers, all these solution gaps are being filled little by little in various jurisdictions, mostly in the US at the moment, but I'm hoping to see more of it in Canada as well. I'm not saying these folks should just walk in the door and do whatever. I think there's obviously a place for regulation, but you regulate proportionate to the risk of harm that they might be able to deliver and the vulnerability of their client group. So I would love to see us collaborate in good faith with other providers of legal services in order to ensure a fair access to the law. As I like to say, people want to help us. We should let them. Okay. That's my envelope pushing on access to justice. Let's put that one to one side and pick up the envelope called lawyer competence. And let's have some fun with this one. Lawyer competence, of course, is a concept that we, a little bit like access to justice, we throw around a fair bit, we talk about it a fair bit, we don't always define our terms very clearly. We don't always put parameters around it to the extent that we might. Lawyer competence, of course, applies both to your first entry into the profession as a lawyer, in the sense that you are not supposed to become a lawyer unless you are competent to do so, as well as your ongoing fitness and competence and ability to practice law, deliver legal services. I tend to focus more on licensing. That's where some of my interest is in these days. But all of what I'm going to say here applies, I think, just as much on the ongoing competence side. And the question I think that should be guiding us when it comes down to the whole question of lawyer competence is the first question on the screen there. What would you want to know about a person before you agreed they should be allowed to become a lawyer? Or that what would you want to know about someone before you agreed they should be allowed to continue to be a lawyer? Right? And I think the reason that's important is that we're talking about the individual person, their attributes, their features, their skills, their knowledge, their character, their fitness, right? And if you can make a list, and I believe that you can, of all of the key features, the elements to say, okay, there's nice to haves. It's nice if a lawyer can do, J, K, L, M, and N. But a lawyer has got to be able to do A. You got to be B. You have to know C. You have to have the elements of D. Right? These are the essentials. These are the non-negotiables. This is the fundamental aspect of being a competent lawyer. I think if you can identify what those elements are, you can construct a framework in which these can be placed and ordered. And many jurisdictions have done this. I shouldn't say many jurisdictions have done this. A growing number of jurisdictions, still quite few, have made frameworks of competence for lawyers. For the most part, it tends to be just for ongoing competence. I know Alberta is doing some very interesting work in this area at the moment. A couple of jurisdictions are creating competence frameworks that apply throughout your career. New Brunswick has done some really interesting work associated with the new bar admission course, and the Solicitors Regulation Authority of England and Wales has kind of led the way in this regard. But a framework can set out the minimum knowledge, skills, attributes, experience, and character of a lawyer. And to give you a little quick example of what a framework might look like, I grabbed this screenshot from the good folks at CPLED and their practice readiness education program. And they call this the mind of a CPLED trained lawyer. And this is a very nice visual representation of many of the elements of lawyer competence. And you've seen it there on the screen. You can read that, and I won't read it out for you. But the idea here, and I should note that the CPLED model does not include legal knowledge, because in the CPLED jurisdictions, it is assumed that by virtue of having a law degree, you have acquired the knowledge, competence necessary to become a lawyer. So to my mind, if we're going to talk seriously about lawyer competence and use it in ways that can actually improve I hesitate to say the word quality, but to improve the quality, the production, the performance, the effectiveness, the professionalism of lawyers, then I think you need to have a rational competent basis of competence and a framework in order to help drive those efforts forward. And then in the terms of the licensing aspect, if someone wants to become a lawyer, let them demonstrate to the satisfaction of the regulator, of the person who's standing at the door, the bouncer at the door to the legal profession with the rope there. A candidate should be able to satisfy that regulator. Yes, I am competent. I have these elements. I tick off the boxes in the framework. I'm ready to come and do this. Okay. Competence frameworks, as I say, it's a burgeoning area. It's still kind of evolving, and people are still kind of working out what those categories of competence might be. I've been digging around with this a little bit. I will suggest to you that I think there are 4 broad categories of lawyer competence that we should think about. Again, I'm thinking here principally in terms of licensing, but I do believe it applies more or less across the board in terms of continuing competence as well. And you can describe these as the knowledge of the law, understanding of your professional responsibility, the skills of a lawyer, and the skills of a professional. And I'm going to talk a little bit, I guess, even for the balance of my time with you here today, I'm going to talk in some more detail about each of these categories of competence. And I'm going to pose to you the question, okay, in each of these areas of competence, how could we adjust them, improve them, innovate them, enhance them in ways that will help us arrive at our access to justice goals? This is what I mean by integrating competence and access together. These can dovetail, they should dovetail. Let's take a look at how you might want to do something like that. Start off with legal knowledge, knowledge of the law, what we learned in law school, such as it was, whenever they happened to be. And we can broadly call this basic intellectual legal skills. And what's that? That's thinking like a lawyer. That's case law analysis. That's legal reasoning. That's statutory interpretation and contractual interpretation principles. It's all the habits of mind that we acquired early in our law school career as lawyers, and then just kind of forgot we learned them. We just kind of assumed it's innate. Private law, public law, and the foundations of law. Those are the 3 elements that the Federation of Law Societies of Canada's national requirements specifies as necessary fundamental necessities of legal knowledge and legal ethics. And this model has been most recently codified in the national requirement, which is coming up, I think, on its 10th anniversary this year. It has been adapted and grown during that time, but I think the root of the idea goes back about 10 years. And it's really helpful to have this. And I think we are reasonably happy with the state of the knowledge of the legal profession when it comes to knowledge of the law. But we can always improve it, we can always enhance it, we can always evolve it forward as we get deeper into this very, very different century that we find ourselves in compared to the last one. So my question here is, if you wanted to, if you will, inject an access to justice element into legal knowledge, what would that look like? Again, throwing out some ideas for you to chew on. What if we came up with some new knowledge competencies that seemed a little better attuned to the reality of the world and to the needs of access to justice? Give you an example. When I went to law school, we spent a lot of time working on real property. And there's a lot of lawyers out there who are today involved in commercial and residential real estate, and that's great. But when I went to law school, which, yes, granted, was a fair while ago, residential tenancies was right down at the bottom of the list of occasional courses. If you're really stuck for third year last term and had nothing else to get, you would often take that. And that probably made sense at a time when everybody bought a house. Everybody owned a house. And when you bought a house, you could feel confident that when you retired X number of years later, what you paid for your house would have increased in value 5 or 6 or 700%, and you could retire to Arizona or whatever it is you want to do with your life, right? That's not the case anymore. Right? We have an entire generation of people today, 30 and younger, many of whom have quite literally abandoned the idea they will ever own their own home, right? It's just not a possibility for them. Right? You know that if you're based in Vancouver. I have friends who are based in Toronto who know that. And in other places like Ottawa, where I'm based, it's not a whole lot better. What if we were to recognize that we are becoming a nation of renters, we're becoming a nation of condo residents, and started thinking, how could the knowledge of lawyers be adapted in order to better reflect that? Same idea around courts versus tribunals. So much of legal education is seeped and it's integrated with the idea of courts and judges and advocates and lawyers banging away in the courtroom and in the discovery room and all this kind of stuff, right? Most great majority of lawyers, they're never going to see the inside of a courtroom, even the ones that go into dispute resolution, right? Going to maybe see a courtroom once every couple of years, but we're going to spend a lot more time in front of tribunals because those are going to multiply, and not just traditional administrative tribunals, but all sorts of other tribunals and street level, community level areas where disputes are heard, aired, and dealt with. I think what I'm talking about here is the idea that the knowledge we require of lawyers has to shift out of the 20th century, shift out of the boomer mentality that created it, no offense to boomers on this one, and into the mentality and the reality of the world that we live in, and more importantly, that people who are born today and next year and 20 years from now are going to live in as well. The other point I want to make here, and I'll make it very briefly, is how about we think about the idea that right now there's really only one place where you can go get the legal knowledge you need to become a lawyer, and that is law school, setting aside, just for discussion purposes here, the National Committee on Accreditation's certificate program for internationally trained lawyers. 3-year law degree, as I need hardly tell you, is long, it is expensive, it creates a whole lot of crippling debt for generations of lawyers. I wonder if there's any way in which we could think about providing some other options for people to acquire those knowledge credentials as well. Just throwing the idea out there, ducking and running to the next topic, which is understanding of professional responsibility. And I'll pause here to say how proud I am of finding this terrific stock image. The actress here nailed it. She's got the look on her face. She's got the disapproving look. She's in mid-finger wag. It's fantastic. Rarely do I find a picture that suits what I'm looking for so well. Professional responsibility in the law has been something that, again, we have tended to define relatively narrowly. It is a focus on the fundamentals of legal ethics, and we know what they are: the confidentiality of client information, conflicts of interest, especially relevant these days in BC, the whole issue of avoiding money laundering. The code of professional conduct, although my ethics course, I don't think we cracked it open one day. Maybe it says more about my legal education. Right? But even when you look at the issues that come up frequently when we talk about professional responsibility and legal ethics, you will find, and I took a look through the professional legal training courses practice materials, and there's a heavy emphasis on things like lawyer misconduct, lawyer negligence, lawyer discipline, lawyer insurance, all these kinds of issues. And that's not to say these aren't important. Of course they are. But I think there's more to the idea of professional responsibility than avoiding messing up things for yourself and for your clients. So again, to inject a little A2J thinking into professional responsibility, what if we expanded the scope of what this term means? What if we were to say to someone who wishes to be a lawyer, there's a whole lot of things you need to understand about the legal profession, about the legal system, about working as a lawyer in any capacity. There is a truckload of systemic discrimination in this profession. There has been for years. The legal system works very differently and much less effectively if you are a person who is Black, if you are a person who is Indigenous, if you are a person who is an immigrant and maybe English is your second or your third language, if you are a person who comes from difficult socioeconomic circumstances. Oh, wait a second, I've just described most of the population, right? And that's not how we learn the law. That's not how we learn professional responsibility. We have a lot of best case scenario in our development in this area. We don't talk about worst case scenario. We don't talk about what if you're running into someone who the system doesn't treat well, who the system treats less poorly than they treat someone who looks and sounds like me. I think that is something worth to think about. To let people know, self-representation is rampant. It's not going away anytime soon. This is how you deal with it. Your personal well-being. There are multiple codes of conduct and multiple frameworks in other professions that are now insisting that personal well-being is a core competence of being an effective professional. Canadian Judicial Council, just a little while ago, well, maybe last year, came up with the same idea that this is part of your competence is being well. Cultural competence, all sorts of different areas that we can talk about. I think we need to expand this. There's so much more to being a good professional as a lawyer, to being a responsible professional than just, and again, I'm not saying ethics aren't important. Of course, they're critically important, but they're not everything. There's more that can be done. Because when you talk about professional responsibility, you have to ask yourself, responsibility towards what? Responsibility towards whom? And I think we have answered those questions quite narrowly in the past, and I think we should think about answering them a little more broadly. And I would love for us to reconsider this whole idea of good character as a means of, as a test for being licensed. Because again, if you basically say, have you ever been arrested? Have you ever been pulled over? I can tell you the number of times I got pulled over before I went to law school is approximately 5% of the number that Indigenous male of my age has gone through as well. It's just not fair. It's not sensible to set that kind of situation up. All right. I want to talk about now the two sets of skills that I think are fundamental to being a competent lawyer. And skills is something we spend a lot of time working on. It's what a lot of bar admissions courses are built around. But I think, again, these are areas that we could dig into a little bit more deeply. Let's talk about lawyer skill, the skills of being a lawyer. Okay, well, there's a lot. As we know, as I need to hardly tell anybody on this call, this is an extraordinarily skilled, extraordinarily adept and proficient group of people that I'm dealing with. And if I were to try to enumerate every single skill you owned, I would be talking up until next year's A2J BC conference, except y'all would have stopped listening. But what are the essential skills of being a lawyer? That's a fascinating discussion. Federation of Law Society says problem solving, an essential skill. I think that's right. Legal research, pretty clear. Legal communication, yeah, absolutely. What does the PLT say? Well, and the PLTC, you are trained in advocacy, writing, drafting, interviewing. You are assessed on your ability to perform in all these skills. That's great. Makes a ton of sense to me. I think it's a wonderful idea. It tends to stop there, though. Most traditional bar admission programs, and pretty much every single you could argue Alberta is a little bit different, but pretty much every single continuing competence regime in Canada leaves it at that, to say these are the essentials, these are the core. And what we really do, this is my estimation, my opinion, your mileage may vary, but I think most lawyer licensing systems slough off a lot of the skill development onto articling. They say, okay, well, you'll pick that up during articling. Right? You'll figure that out in your first couple of years of practice. A, I don't think that's true for a lot of people. B, even if it was true, it is a disservice to the lawyers who have to go through this. And C, it's a real disservice to the clients who are out there getting trained on their dime and their issues while people figure out the skills that they need in order to be a lawyer. So that's fine. We can have a separate conversation, which we're not going to have now because we don't have the time, about lawyer skills. How would you maybe adapt this approach, adapt this area to increase and infuse some more access to justice? Well, it is hardly a surprise that we are all talking about new approaches to supervised practice. This is what I prefer to use period of supervised practice rather than the articling term, because articling positions, as again, I need hardly tell you, becoming much harder to find. They have a whole lot of difficulties and controversies around them. I know BC is talking about a lot of these issues at the moment, but even beyond that, there are studies coming out, like 4 provinces have put together 2 studies, Alberta, Saskatchewan, Manitoba, Ontario, that have found between something like 20 to 30% of all articling students report they've experienced some harassment or discrimination or abuse over the course of their articling term. Now, 2 to 3% would be deeply objectionable. 20 to 30% left unacceptable in the dust back quite some time ago, right? We can't have that. You just can't have that going on in an essential, in a mandatory aspect of your licensing system. Okay, so again, separate conversation, but there's no question in my mind that among the reforms that we need to make that we're going to improve access to justice, we've got to take a different approach to the period of supervised practice to ask ourselves, what are we trying to accomplish? And is it creating barriers to entry? Because again, if you are a person who is from a background, from a community, from an ethnicity, from a socioeconomic circumstance that makes you, for whatever reason, usually a bad one, less attractive to employers who might hire you for an articling job, then, well, we know the results. We know how difficult it is for those people in those situations to get an articling position. That's a barrier to entry. That's not on, okay? Other point I want to make here, if you are not familiar with the term trauma-informed lawyering, I suggest you become so. I think this is going to be emerging very fast as a required competence, as a core element of being a lawyer. Because again, best case scenario lawyer training, best case scenario lawyer imagining says, here comes a client into your office and they are well dressed and they are calm and composed and they speak English perfectly and they're this and they're that, they're the ideal client. Those people don't exist. Many of the people who are coming to you, no matter what their circumstances, they're kind of a hot mess, right? They're in a lot of trouble. They're going through a lot of anguish. They have real serious issues. And then there is the additional segment of the population that have undergone trauma, especially the case in family matters, especially the case in criminal matters, especially the case with clients from racialized communities. We need, as lawyers, the skills to be able to relate to, speak with, understand, connect with people in those circumstances. We simply don't have that. It is never delivered to us. We got to develop it. And I think we need to develop it about 5 years ago. Okay. Last point I want to make here is the broad category of professional skills, which I separate for discussion purposes from lawyer skills. Obviously, they all kind of work together in a certain sense, but these are skills that I set apart because they're not exclusive to lawyers, right? Any professional needs this. If you're a doctor, you're an architect, you're an accountant, you're whatever, run off all the professions that you know in your mind. These are skills everybody should have. And when you talk about professional skills with regulators, with professional indemnity and insurance providers, they will tell you it is failures of these skills that are by a staggering margin the leading cause of complaints by clients, of claims against lawyers, of damages paid, of discipline, all these different areas, okay? So professional skills is an on-the-ground, real-world matter that lawyers need to have more of than we do. And we need to spend a lot more time introducing and upgrading these skills. Again, this is not just a question of licensing. This is ongoing. I wrote a piece several years ago to say, if you're going to have a mandatory CLE system, and I'm not a big fan of those systems at all, then here's what I think you need to do. Go talk to the regulator, go talk to the professional indemnity provider and say, what were the 5 leading causes of complaints against lawyers over the last 5 years, 1 year, doesn't matter. Get that list and say, all right, that's what MCLE is going to be this year. We're going to focus everybody on these issues. I guarantee you that people will spend a lot more time dealing with their MCLE work. They will be a lot more engaged, and we will see an improvement in the overall impact on lawyer discipline and practice. Okay, but that's not A2J. This is. What if we were to give people the skills to say, let's deliver legal services better, faster, and cheaper. I've written at some length about the concept of frugal innovation, making innovations not to add more bells and whistles, but to take them away, not to make something more fancy and exciting so you can charge a higher price for it, but so it meets the minimum needs of communities and markets that have limited resources to acquire your services. This is something I think that we should be adopting as a discipline in the legal profession across the board. And I would love to see more emphasis on these professional skills, client relationships, the client experience, customer service. I think we're allowed to call them customers from time to time because that's what they are fundamentally. The use of technology. Many codes of conduct now introduce ideas of a mandatory technology competence, but then the skills which are essential to your ability to function over the course of the day: organization, management. Those two areas alone, I think, have a tremendous impact on lawyers' ability to function properly. Develop more empathy, to acquire the habits of cultural humility, to have the skill of financial literacy, absolutely essential for every kind of legal work you could do. And all of these areas, every time you get better at this, you are increasing access to justice, either because you're providing more legal services to more people, or you're providing better, more fulsome, more effective legal services to people. Both of these things can and should mean access to justice. Coming up on time, which is good because I've got basically one functional slide left, and that is essentially to say these things work together. The whole idea of access to justice and competence can and should reinforce each other. I would not like to see discussions of these areas proceed in separate parallel tracks. I mean, yes, the issues they raise and the considerations that come into it are distinct, but there are commonalities, and at the very least, they need to cross paths from time to time as we head down that road. That is my contribution to this conversation. It has been a pleasure for me to have had the chance to chat with you all about it all. And Carrie, I'm going to turn it right back over to you.
Thank you so much, Jordan. That is a lot of information to take in, but that's why we're all here. You know, the people who are online today come from faculties of law. They are faculty delivering legal education to law students. We have members of public legal education groups. We have students. We have practicing lawyers. We also have our incoming Deputy Attorney General, Shannon Salter, with us here today, which is fantastic. I think that we have all these people here is because we all know we're having these conversations. We're having them at the Law Society level when we think about alternative pathways to articling. I know CBA British Columbia branch has had conversations with its provincial council about what we need from graduating law students, and then what do we need to make sure we're providing in articling. So these are the kinds of pieces that are being talked about. Yesterday, as part of Access to Justice Week, we had our session on innovations in legal practice. And all three law schools were connected to look at how to prepare for a multidisciplinary future in a person-centered justice system. And we had practicing individuals from lots of different backgrounds come together to talk about what this looks like. And that is connected to what today's discussion is all about. I'm going to invite our next, to Steve McEwen QC and Lynette Jung to join us here. And I'm going to introduce them to all of you, because we're now going to shift our focus from this framework that Jordan has talked about to engage in what this looks like in practice. So Lynette Jung is the Deputy Director, Legal Resources, Learning and Development with the BC Prosecution Service. She has been a practicing lawyer since '93 and worked as a prosecutor since 1997. In addition to being part of and managing the high-risk offenders team, she is also responsible for the continuing legal education program for the Prosecution Crown Counsel and administrative professionals who work in the BCPS. She's also contributed to the CBA's professional development through its various committees over the years, and she's also involved with the Association of Continuing Legal Education in North America. And so Steve McEwen is a partner at Blakes, Castles and Graydon LLP, and his area of practice, securities, mergers, acquisitions, and corporate governance. Not maybe a place where you think about access to justice concerns, but they are certainly an area that we can talk about what we can do differently. Steve was first elected as a bencher of the Law Society in 2016, and among his contributions, he is currently chairing the Law Society's Lawyer Development Task Force. He was called in, 1998 in British Columbia and in New York in 2002. And he has also been a contributor to CBA's Securities Law section. So we brought these two people to join the conversation with Jordan to talk about what these ideas look like in real life. So I'm going to invite all of you who are listening to continue to put your thoughts and comments in the chat for everybody to see. But if you have a question, use that question and answer box and put in a question there, and we will weave those into the next segment of today. So I want to also mention that both Lynette and Steve wear multiple hats, as you can tell from that introduction. But today they're participating in their own personal capacity. Lynette's not here on behalf of the BC Prosecution Service. Stephen's not here on behalf of the Law Society or any other of the amazing organizations that they work with. So they're here to share their thoughts because they've been thinking about what this looks like in real life, and we want to hear from them. Lynette, when you were listening to what Jordan was saying, especially about how our skills and knowledge and professionalism could be enhanced if you overlay the access to justice lens, what were your sort of first reactions about that and how you see that happening in real life in your practice?
Thanks, Carrie, and thanks for having me today. It's a pleasure to be with all of you. And as Carrie said, I'm speaking on my own behalf as a lawyer who's practiced criminal law for a number of years. When Jordan was speaking about how to overlay the professional skills discussion with an access to justice lens, I was thinking about a lot of the good work that's going on within the province of British Columbia, and I just added it to the chat. One of the ideas is that the trauma-informed practice curriculum is available free of charge for all lawyers in BC, and I'd highly encourage people to take the course. It's available through the Justice Institute. You can register, and it's a great online course. It was produced in partnership with funding from the Department of Justice Canada, and a number of key stakeholders in BC helped create a really good curriculum. And that's one way that I see our attempts to address access to justice obstacles. So in my work in criminal law as a prosecutor, trying to look at how do we remove the barriers from participation in the justice system. So taking a trauma-informed approach is one way, and another way is to look at different ways of breaking down the barrier between the lawyer and the witness, and the lawyer and the victim, or the lawyer and the client. And that would be to commit to the use of plain language, commit to digital literacy, taking a trauma-informed approach, and staying current with the law. And I think all of these different ideas will help us work towards improving access to justice. With my organization, we've committed to addressing the overrepresentation of Indigenous people in the criminal justice system. And we're committed to that through our Indigenous Justice Framework. And I didn't create it, but I have the benefit of living through it with my organization. And we're now into the third round of policy changes for Crown Counsel in British Columbia that really try to address the reasons behind the overrepresentation of Indigenous people in the criminal justice system, not only as offenders and accused people, persons, but also as victims. We have a serious overrepresentation of Indigenous women and girls as victims of crime, and we're trying to work towards reducing that overrepresentation. So, Carrie, those are a couple of ideas about the good work that's happening now in our province, but I think we've got a long way to go.
Thanks, Lynette. Steve, I know that as a practicing solicitor of years of experience, you come to this conversation perhaps with a really different perspective than what we're used to hearing in the access to justice field, or maybe it's actually the same. What were your initial thoughts as you considered this framework and how you see some of these ideas showing up in real life?
Well, I'm very encouraged that the dialogue around competencies is becoming so mainstream amongst people who think about how lawyers ought to be trained and how they ought to be prepared to help the public with their legal issues. Because I think that, like you said at the beginning, I'm not speaking on behalf of the Law Society here, I'm speaking on my own behalf, but I am the chair of the Lawyer Development Task Force, and that's one of the things that we're confronting is how do we go about ensuring that lawyers are trained and lawyers develop over the course of their career in a way that is actually in the public interest. And so I'm very happy that competency is part of that dialogue. But one of the things as a solicitor, and Carrie asked me to speak about the issues I see as a solicitor with competencies and access to justice in British Columbia in this talk. One of the problems I think that we as a profession have is we tend to think of access to law as being the same as access to justice, and it's not. One of the competencies that I would very much like us to all stress, and I think that even more senior lawyers, and this isn't a knock on the law schools, this is, I think even more senior lawyers can be fairly bad at this, is assessment of risk. We are often asked by our clients, how bad is it? Like, what am I facing here? What is going to happen if I do X? How likely is it that the bad result or the costly result is going to occur? And you'll often see with junior lawyers, but we all know it happens a lot with senior lawyers as well, that you'll find a long litany of the law as it applies to the person's situation is easy enough for a lawyer to generate. But a description of the actual risks that the person faces and how to go about making a decision about the risks that the person faces are very difficult things for lawyers to address, because we're taught and we have a culture of spotting issues, but we don't have a culture of ranking issues. And I think risk assessment is a competency that we all need to get better at. And from an access to justice perspective, risk assessment is incredibly important. When you're dealing with people who have limited resources, you cannot squander their resources on a long Easter egg hunt of all the various potential legal issues that may apply to their circumstance. The most, when you're talking about the kind of work that I do, where dollars and cents are involved, a small issue of $3,500 may have exactly the same number of complicated legal issues as an issue of $3.5 million or $350 million. It's just that there aren't the resources there to chase those things down. And so you need to be good at assessing what matters in the thing that the client is presenting to you. And from an access to justice perspective, if you can't, if a person's only got a time to have an hour session with you, we need to get better at being good at honing in on those things that matter. And I think that is a competency we don't stress enough. The other one I wanted to raise was financial literacy, and Jordan did reference it at one point in this presentation. I think financial literacy is another matter that we need to think about as part of the core competencies of lawyers. 40% of lawyers in this province are solicitors, and civil litigators, which make out of, which I didn't go and look up the number unfortunately beforehand, but make up a substantial chunk of the rest of the province's lawyers, deal with dollars and cents all the time. Family law deals with dollars and cents all the time when you're trying to decide, if there's a corporation involved? How do you get at that money? Where is the money? Who has the money? How do you garnish the money? These are all questions that lawyers are regularly faced with. And yet we don't come into the profession with a particular set of financial literacy skills. We don't stress that in our CPD, and we don't, most lawyers that I know who have financial literacy either got it some other way because they had an undergraduate degree that lent itself towards that, or they just learned it on the job and figured out what needs to occur. But knowing how mortgages work, knowing how to garnish wages, knowing where bank accounts, how they work, how to get at that money that's in that bank account, having that financial literacy and not having to learn it on the job on your client's dime, or if your client doesn't have a dime, just not being able to advise them on it is just not helping our clients. Especially when you think about, again, from an access to justice perspective, you just don't have the resources to be able to learn this stuff when you are presented with it for lawyers. I volunteer at a pro bono clinic every month for not-for-profits and artists to provide them with free corporate legal advice. And probably 30% of the questions I get asked come down to, I'm trying to chase this person to pay a bill, and if I don't pay that, this bill doesn't get paid, I will not be able to pay my lease this month and keep my gallery open, or whatever the not-for-profit is doing. If you don't already know how to go after funds and know how funds work and where money is and what money looks like when it's being hidden, you don't have the skill set to actually help your client in a efficient and timely manner so as to be able to actually address the needs that they have come to you for a solution. And so I think that if I had to take two from the solicitor's world and raise them up and say, hey, we need to get better at this stuff, I would say risk assessment and financial literacy. If we could do those two things better, I think we can serve our clients better and more efficiently.
Thanks, Steve. I really appreciate how you talked about the work that you do pro bono for those artists who actually need the mindset of running a business and all the factors that come out of that. And that is a perfect example of access to justice for an underserved population where there are limited resources in place. And so that's a great reminder to all of us that there is a connection between that business transactional world and access to justice that some people sometimes forget is there. When we were developing this program, we wanted to make sure we focused on the person, the client, because the client experience, the user experience, the people we serve, thinking about with criminal prosecutions, the witnesses who are involved with the presenting of evidence, and the people who have been accused and need to have the system very function in a way that makes sense to them. When we think about that very person-focused approach, what are some of the competencies that you wish more lawyers had, whether they've learned it 20 years in, or whether they're learning it as they walk out the door and into the profession? Lynette, do you want to take that?
Sure. Thanks, Carrie. So I think there's three different competencies that lawyers can develop so that we can remove some of the barriers from participation in the justice system or obtaining effective legal services. The first is all lawyers need to educate themselves about implicit bias and their own biases. There's so many great courses that are available, and most of them are free of charge. And they really help you to understand your blind spots and really fill in the parts of Canadian history or the history of the legal system that you just didn't learn in law school or before that. And they help you to assess the way you're communicating with people, whether they're clients, other lawyers, other professionals within the legal profession or the justice system, or in my case, with victims and witnesses. And it just helps you reframe the way you're going to communicate with people so that you can do that in a respectful and effective way. For example, we were lucky enough last year to obtain some federal funding from the Department of Justice. And we created 6 videos in plain language, and we've posted them on our website so that witnesses can watch these videos before they even meet with a lawyer in order to testify in a criminal proceedings. So we now send that, we have a QR code on a sheet that comes with their subpoena, And if you scan the code, it'll take you straight to our website, so that as a witness, perhaps your first language is French, we've got a video in French. It's in plain language. And what we've done is we've just helped to remove some of those barriers to participation, and we've helped to make the legal system more understandable for real people. I think something else that lawyers can do is commit to continuing legal education and developing their emotional intelligence in a responsible way. So lawyers must be empathetic so that they can connect with their clients. They don't have to live their client's problem, and but they do have to understand it so they can understand how they can be of assistance to their clients. And I think the third area that we've really made some significant progress in, it's the competency of recognizing that as lawyers, we're not, battle ready. We don't come equipped with emotional sets of suits of armor, and that we have to take steps to take care of ourselves so that we can be effective and professional and lawyers and maintain our good health across the years of our careers. So I think we've really made some good progress in that area, and I think it really is a competency. It's a competency of saying, if I'm not doing well, I have a duty to get some assistance or do some things differently so that I can be ready to practice, ready to interact with my clients or witnesses, and be resilient so that I can deal with the fact that practicing law is a stressful profession. And it does take a lot out of you, but there are ways that you can maintain your health and increase your health. And I know that all of us struggle with that on a daily basis, but I think the legal profession has done a good job lately of really turning our minds to that and offering a lot of education in that area. I really applaud CLE BC for their great symposium on mental health last year. I thought that was an excellent program. And I applaud the Law Society for really embracing accrediting health and wellness programs, because I think healthy lawyers are more effective lawyers who get sued less and have less complaints to the Law Society. So I think those are three areas where we're really developing our competencies.
Thanks. I'm mindful that we have a few questions, some of which were directed to Jordan. So hopefully, Jordan, you can come back. But we also have a question that probably much focuses very specifically about some of the conversations we're having here in BC. Where should these skills be taught? In a law school? Should it be something in articling or as Jordan refers to it as supervised practice towards licensing? Steve, do you have some thoughts on that as a human, not as a Law Society venture?
Yeah, well, I've got thoughts with both hats on, but I'm not going to have a Law Society hat on right now. I think Jordan has done some really interesting work with the Law Society of Alberta to identify competencies. And one of the things that is part of the conversation in British Columbia about addressing some of the systemic problems we have with how we license lawyers is figuring out whether or not there's some alternate paths to articles available out there. Now, I understand this is an Access to Justice symposium, so I'm not going to try to hijack it. But I think that by creating more pathways, we actually do address some access to justice issues, because of course, if you look at the folks that are disadvantaged by the current system, it shouldn't surprise anyone that they look a lot like the folks that are disadvantaged by so many Canadian systems. And so I think that it is part of access to justice in a way to think about these things. And I like the fact that competencies are part of the dialogue, because if you figure out what competencies a lawyer ought to have, then you can say, okay, well, here's the competencies, and here's what lawyers do. Lawyers take CPD, lawyers go to law school, lawyers article, lawyers go to PLTC. Which of the competencies that we think are the sort of core competencies for lawyers, which ones do we think are being served and which ones do we think aren't being served, and will allow us to have a rational yardstick to compare all of this against so that we can build a training system, whether it's at law school, whether it's at PLTC, whether it's in CPD, so that all of these competencies are addressed rather than just hoping they get kind of organically accreted over a series of various stepping stones that we're making people go through. Because I think that when folks think about licensing and about continued licensing for lawyers, I think that a lot of what has come to this point about requiring law school, about requiring PLTC, about requiring articles, about requiring CPD credits to be maintained over years is all about making sure that lawyers continue to have the competencies needed to protect the public. But I don't think that we've been all that rigorous about defining what those competencies are so that we can then go forward and make sure that they're actually out there. So Jordan has done some work with the Law Society of Alberta, which if you haven't read it, I really commend anyone to read the report that he gave the Law Society of Alberta, because it's really interesting stuff. I don't know that I 100% agree with the list of competencies that Jordan came up with, but I'm not saying I don't 100% disagree. There's that. But I do think that it is a great lens with which to look at, are we teaching ourselves, are we requiring ourselves to have the right skills so that we can better serve the public? And I think that from an access to justice perspective, I think that if we were better at some of those competencies, we could bring the cost of legal services down. We could provide services on a more cost efficient and more effective basis to a broader group of people. It's not the only thing that's going to address it. As Jordan was indicating, 85% of legal needs are anticipated or estimated to go unmet. And so you're not going to address it just by getting more efficient in our current system. That's only one thing that we can do, but it is one thing we can do. So where should they be taught? Everywhere. All the places we're currently teaching people, and perhaps other places as well.
Well, if the chat is any indication, there are lots of people in the room tonight who have their go-to sources for building out libraries for clients to help them understand things in advance, or witnesses to help things in advance, like Lynette has pointed out. We've seen accolades for CLEBC. I know when it comes to Indigenous cultural competency, there's a lot of excellent work going on there. So the bit about everybody doing things is a good one. And all phases, all stages doing that is fair, except we have limited resources and we can't be asking people to pay twice and 3 times for things. So we do have to eventually get to that part of the conversation. Jordan, there are lots of questions for you about regulation generally, and I'm gonna try and reframe them a little bit so we're focusing on the competency piece. So one of the questions was about the difference between people law and organizational law, where you're representing institutions or those bigger things. Is there a difference in competencies? Should we have a difference in the competencies for one thing or another?
It's a great question, and the whole concept of people law itself is really interesting. I think the phrase was most recently coined by Professor Bill Henderson, University of Indiana Law. If you don't read, by the way, a website called Legal Evolution, please do, because there's brilliant materials posted there every week that are very thought-provoking. A lot of these sorts of issues about the future of law. And people law and organizational law is a pretty decent way to describe two very yes, obviously quite similar in many respects, but very different markets or sectors. The way I would kind of answer the question around competencies and like what should be required of you if you're going to serve each of these areas, I think a lot of it comes down to, again, what's the purpose of the competence? The purpose is to make sure that the client is well served in every respect. And so then I think you come to the core question of all regulation, to my mind, right? Now, this is, again, my theory of the point of regulation is not just to protect the interests of the public, but to advance the interests of the public, to expand it. I worry sometimes we talk too much about, oh, we must protect the public, which suggests we had to protect them from anybody who's, not one of us. And I think that's a very defensive, crouching kind of shrinking approach, where I think especially to tie into the whole idea of access, how do we expand the interests? How do we advance the interests of the public? How do we improve them and enhance them? And I think in that regard, if you're looking to talk about those kind of competencies, and you want to guard against the risks, the fundamental question is, what is the nature of the risk that you're guarding against, right? If there was no risk to clients and customers of legal services entities, there would be no need for regulation, right? Fundamentally. But there is. And every kind of legal service carries a different level or element of risk. I think the job of a regulator is to identify what is the nature of the risk that we are protecting against. And I think that's always going to be in a bit of a sliding scale, right? Because there's different elements. There's the likelihood of the risk. How likely is it that something's going to go wrong? There is the payload of the risk. If something goes wrong, how bad is it going to be? Is it going to be like, ooh, owie on my finger, oh my gosh, my arm's off, right? And then there's a question of the vulnerability of the clients, because some clients are going to be in a much more vulnerable position. And if something goes wrong, it's going to be much, much worse for them, or they are much less able to take care of themselves. And this, I think, goes to the question of people law versus organization law. We make an assumption, perhaps it's actually a presumption, which is maybe a bit more defensible, that organizations and companies and corporations and businesses have a greater level of sophistication. They're able to know their own interests better. They're able to make better informed decisions versus your average individual who simply does not have this kind of vocabulary, this kind of training and sophistication. In that case, and if again, that's a lot of ifs to get us to this point, but I think you need to have a different kind of regulatory approach to individuals, to people law, and the competencies that are involved there have to be really grounded in those risks. Because again, and this is a larger point which we don't have anywhere close to the time to make. The purpose of regulation, and this is not my line, it belongs to someone from Britain. The purpose of regulation is to set a floor, not a ceiling, right? What are the minimum requirements in order to protect and advance the interests of the public? Identify those, regulate around those, identify competencies for those, and then I think you're on the right track for both protecting and advancing the interests of the public.
As I listen to this conversation, I am reminded again how interconnected all the different conversations are, and that this is actually complex. It's not enough to just say, oh, so and so should do this, or this group should do that, or we need to make sure that lawyers can do these skills. It's so multifaceted, and it requires us to have more of these conversations in groups. I'm loving the chat to see how engaged people are with putting this information, their own thoughts, appreciation for what's happening here. But we're coming to the end of our time tonight. So we could go on for hours, but we really are at the conclusion of today's session, except for one important piece. This event is brought together under the auspices of Access to Justice BC, an umbrella organization that brings like-minded people, institutions together to have these conversations. And I'm going to ask Chief Judge Melissa Gillespie of our provincial court to take on that role of reflecting person to take a look at what have we talked about today, and her thoughts on how what we've talked about connects to access to justice as we head off for the rest of the evening.
Thank you, Carrie, and thanks to our panelists. It's a great privilege to be here tonight, listening to everybody and sitting shoulder to shoulder with the panelists. And of course, Jordan in his keynote speech. It's a very interesting time, I think. And I also just want to thank everybody for taking time today from their very busy schedules to come and have this conversation. And I see 104 participants. That's a tremendous amount of people who are so interested in what is the transition for our legal systems at crossroads, for example, when we continue to be faced with complicated questions about improving access to justice. It's a dialogue because, as Carrie says, there are so many different facets that arise in the context of so many different systems and so many different challenges for people, for young lawyers coming into the profession and learning how to provide services to people who historically may not have been considered as people who are focused on for access to justice. The fact that we now have a week dedicated to access to justice issues, that there's a great collaboration with the law schools and more of a dialogue, I think, about what students see as they're coming into the legal profession, about the competencies that they need to situate themselves to serve a new and a rising array of different legal issues that are confronting us as the world's changed, or the world that we live in changes. I think we've I can't say come through, but are presently continuing to be in a time when we are all very challenged by the impact of a worldwide pandemic. And we're seeing, even in the last several weeks, a lot of discussion about what that means for people. Justice systems have had to challenge themselves over the course of the pandemic, for example, to be able to respond and provide continued access to justice for people, and people who have legal problems in the context of great barriers to accessing courts in person. And it's actually, I think, highlighted some of the challenges even more so, but also some of the resilience in the justice system. And I think what is our greatest strength in this province is the willingness and capacity of people from all different areas to come together and to collaborate and to speak about how it is we can move things forward. In the past, pre-COVID, justice system reform was much slower, and there were fewer conversations about what needed to happen in order to improve access and in order to better equip new people who are coming into the legal profession to provide services to those who desperately needed it in order to resolve and solve legal problems. I think we're coming together in more meaningful ways. We're all listening to each other in more meaningful ways because we've had to develop solutions that are much more sort of focused on the user experience. The A2J group in BC draws in a number of different people from different areas of practice, but also lay people who have an enduring interest in access to justice. So I commend everybody tonight for all of their thoughts and their comments, and I'm delighted to be able to participate here tonight. So I think as we move forward, we do have to think about different ways to engage and to think about as well how we provide legal services to people in the very remote locations of our province. Technology has been very helpful, but I think one of the things that we've learned through technology in the past several years, yes, there's a need to be technologically competent, but there's also a need to ensure that people aren't being left behind as we move to technology in many ways to improve access to justice. We can't be leaving people who have challenges accessing technology or living in places in communities where there simply isn't the bandwidth to support that. And we see there the real importance of navigators within community to help those people who either don't have access themselves to the devices and the connectivity, or who may not have the skills or the language to overcome those barriers. So as we move forward, we have to make sure we're not leaving people behind. And again, that's something that is, I think, necessary to incorporate into competencies for lawyers to fully understand what it means to be able to connect in a meaningful way with clients and people who have legal problems and are looking for places for those to be resolved. I can say that there have been a lot of discussions as well at the provincial court in the last several years about how to improve access to justice for people in the province. And I think those conversations are taking place in many different areas around the province. Particularly, we see great advancements in our family law with the new family law rules. And we see, for example, justice access centers operating, in particular in Victoria and Surrey, where their early resolution processes are in place to integrate families who are experiencing legal problems as they are separating, to come firstly to a Justice Access Center and to connect through that with family justice counselors, and to identify what problems can be resolved through collaborative mediation and those which may require them coming to court, narrowing issues, and being certainly in a place where there's much smaller issues generally between them that need to come to court to resolve those issues. The advantage of that, accessible, done virtually in many places, timely access, and giving people early answers for their legal issues, which is something that is really important in the context of courts and in the context of the legal issues and problems that people face. So thank you very much. I really appreciate the opportunity to share this time and to be a part of this great presentation tonight, and everybody's thoughts in the chat, as Carrie indicates, has been incredibly engaging. So great opportunity for all of us to think about these things and move forward.